Okay. Joke Aliu's experience cuts across dispute resolution and corporate practice. She has represented several multinational and local companies and individuals in complex, high-value arbitration and litigation proceedings in local and regional courts, arising from a wide range of matters, including oil and gas, maritime, employment, shareholder disputes, debt recovery, and human resources. Joke also has acted as a joint expert in Nigerian law in proceedings at the Truro County Court, United Kingdom. She represented the family of the late Gambian journalist Dedra Haidara in a successful suit against the Republic of Gambia at the Community Court of Justice, ECOWAS. She advises on company formation, regulatory and compliance issues, and regularly engages with key regulators. She's a notary public of the Federal Republic of Nigeria. Welcome, Joke Aliu. Glad to have you here.
Thank you. Thank you very much, Murphy.
Okay, so you have the floor. Let me allow you to jump right in and start.
All right, thank you, Murphy. So, when I was looking at these topics and you said 12 things to note, I started wondering why you chose the number 12, and I was wondering, I know Murphy is a pastor, was he inspired by the 12 disciples or something? Why not 10, why not 15 or some other number, but, and just to say that the number 12 is by no means exhaustive. So we'll just be looking at a few things. And I'm hoping that at the end of this session, of this discussion, we will know the areas to look out for in contracts. We will know the proper questions to ask when we're entering into contracts as well.
Okay.
Well, just to also say, this is not legal advice, and I'll be speaking from a Nigerian law perspective. I'll try as much as possible to give examples just to drive home the points, because I'm sure that many of the situations I'll be talking about, we probably have found ourselves in one or more of them. And one of the things I've noticed over time with businessmen is that businessmen are very, very optimistic. They want to sign time. They believe that lawyers are just a clog in the wheel. These lawyers just want to waste time and all that, and sometimes they can't even see the value in paying lawyers for their services. So they go ahead with the contract without, seeking legal advice. And then when trouble comes, they come back to the lawyers. So while lawyers, and I think I can speak for most lawyers, while lawyers are also interested in ensuring that, you reach an agreement, and that you begin to execute your contract, lawyers are thinking of several things when they're advising you on a contract. They're thinking, for instance, they're saying to themselves, how do I ensure that the terms of this contract are clear, such that if there are any issues in the future, the parties can come back to this contract and answer the questions that arise without ambiguity? How do I try to provide for as many scenarios and situations as possible? How do I ensure that this contract is executed, with ease? How do I, ensure, and how do I even prevent a dispute from occurring? So that's the way lawyers are thinking. And sometimes, because there's such a gap in the way a lawyer is thinking and the way the businessman is reasoning, you can find that the businessman can be a bit impatient. So I'm now going to our 12 points. And my point number one is this: be very careful about how you use contract templates or standard contracts. And what do I mean by that? Many of us have this practice of just calling a friend and saying, please, do you have a software contract that I can use? Do you have a software contract that you can send to me? Do you have a lease agreement that I can use? Now, it's not bad to work off existing contracts. It's not bad to work off existing templates. There are even advantages. One, you don't have to reinvent the wheel. Secondly, you may not have to pay a lawyer if it's a simple contract and you already have a standard form. But you need to be careful also in adopting standard contracts or templates. And I'll give you a few reasons why you need to be careful. The first is that no two situations are the same. How did you find two situations or two circumstances or two business relationships, even where they're in the respect of the same subject matter? How did you find two that are exactly the same? So in adopting a template, you must be careful to adapt it sufficiently to suit your own situation. The second thing is that if you adopt a template that is not really a recent template, and if the law has changed between the time that that template was prepared and the time that you are now preparing your own contract, the chances are that you will miss that difference in law, that change in law. And if it's such a fundamental change, it may impact your contract and even impact the enforcement of your contract. Sorry. The third is you should ask the person you are getting the standard template from. You should ask the person, whose side were you on when you prepared this document? Because I mean, you will be asking someone for a tenancy agreement, and you may have drafted that tenancy agreement for a land, negotiating that agreement. You may find that that agreement is actually tilted in favor of the landlord, and it's not as well negotiated on behalf of the tenant. So you actually need to be careful when you are using template contracts. That's our point one. Now we'll go to our point two. And our point two is you must do your due diligence. Now, I'm not saying, of course, due diligence can be of different scopes, depending on, the type of contract you're going into, depending on the value of the contract, and even on the risk involved. But there are certain minimum things that you should actually just find out about. There's a entering into a contract, and I'll give you a few examples, right? So first of all, you should know the person you're dealing with. Be very clear about the party you're actually dealing with. Now, I know that very often people assume that a product name is the name of a company. Now, a company may be producing, manufacturing a product. The product would have a name, but the name of the company may be entirely different from that product. So say, for example, Murphy, you are meant to supply flour to the makers of Indomie noodles. And you just assume when you are preparing the contract that the name is Indomie Noodles Limited. Meanwhile, there's no company like Indomie Noodles Limited. And when it comes to the time for enforcing the contract, if something goes wrong, you then need to cross that hurdle of establishing that the person you actually meant to contract with, is the company actually registered, having a different legal name, from Indomie Noodles Limited, because no company probably exists in that name. And I'll give another example, and this is a real life example, where a group company having several subsidiaries was dealing with another company. Let's call the other company Company B. And in the course of executing or agreeing, coming up with the contract, they actually mentioned the name of the group, more like the trade name of the group. The other company, that's the company B, did a bit of research and came back and said, well, I want to use the specific name of one of the subsidiaries, and then supplied the name of the subsidiary it wanted to deal with, the name that it wanted to have in the contract. That name was inserted in the contract. It turned out that the subsidiary that it identified was actually a dormant company, having no assets, having no money, and it wasn't the operating subsidiary of the group. So you can imagine when issues went on with the contract and he wanted to enforce the contract. And he then was trying to tell the court that, well, it was a mistake. I actually wanted to deal with the operating subsidiary and not this dormant company. And the court said, well, to the extent that you were the one that supplied the name of the company that you wanted to deal with, we can't take it as a mistake. So you can see how these issues, how these questions can actually work out in real life and the kind of issues that you may face. So it's important for you to know the legal name in which the company you're dealing with is registered. And I'm talking about when you're dealing with companies now, maybe different when you're dealing with individuals. But you must be, you must state the company's name with enough specificity, that makes it easy to identify without ambiguity, the company that you actually intend to deal with. So that's still on the need for you to do your due diligence and to identify the person, the real company, the real entity that you want to deal with or that you're dealing with.
Great.
The second point I want to make on your due diligence is the need to know the book that you're getting into. And part of this you can only uncover through some degree of due diligence. So I'll give some examples. And for those who are a bit familiar with property deals, you will know that certificates of occupancy are usually granted for maybe 99 years or for 50 years, right? So there was a party who went into a contract with, a contract for purchase of a property. And he was very happy to sign the, the deed of assignment, because he had seen the original certificate of occupancy. And he had seen that, well, it belonged to the person who wanted to sell the property to him. But it was only upon further investigation when he actually read the specific terms of the certificate of occupancy that he saw that, number one, it was granted only for 50 years. Number two, it was granted 35 years ago. Now, if it was granted 35 years ago, what it means is that it remains only 15 years on that certificate of occupancy. So he's buying only 15 years ownership of the property. I'll give another example of it, and this is also a land property, a party wanted to buy property. He was very eager to conclude the transaction, only to then discover, only to then be advised to, at the minimum, do a search at the lands registry. He did a search at the lands registry, and the property was going to be sold to him for about 35 million naira. He did a search at the lands registry and found out that the person who wanted to sell the property to him was owing about 20 million for ground rent. So what this essentially means is that if he had gone ahead with that property before knowing this, he would have paid 35 million and would still have had to clear the 20 million that the guy was owing for ground rent. So what am I saying? Am I saying that when you see these things, you walk away from the transaction? Maybe not, but at least you know what you're getting into and it helps you to bargain appropriately. So if the transaction you're dealing with has to do with licenses, leases, all those things that have some kind of certification, you want to check to be sure that the certification is still valid. You want to check to know the term of years under it, because these things may actually affect the way you bargain or the price that you're willing to pay. Yeah. So on that point, do your due diligence. So I'll get to the third point, which is ask yourself or ask your lawyer, should this transaction be in a particular form? Now, generally under Nigerian law, transactions are not meant to be in any particular form. Agreements are not meant to be in any particular form, generally. So they can be oral, they can be by conduct, they can be in writing. But as with everything that concerns the law, you have a general rule and you have exceptions. So there are exceptions, and there's some types of agreements that must actually have these specific forms. So if it's an agreement, for instance, to transfer or to sell your interest in land, an agreement for sale of land, it must be by deed. So you should ask yourself, is my contract in the right form? If it's an agreement between yourself, between you and me, for instance, Murphy, and you want to provide me with architectural services, but I won't be paying, right? Ordinarily, I can enter into that agreement with you. But to the extent that I will not be paying, if you don't perform the agreement, I won't be able to enforce it against you. Yeah. Because one of the crucial elements of a binding contract is that I must be paying something for it. There must be consideration, right? But if I want to be able to enforce that contract against you, even without me paying, yeah, then I should, so that's then different. If it is executed as a deed, then that may take care of it, and I may still be able to enforce it, provided that other elements of contract are fulfilled. Okay. So you should actually ask yourself, is this my contract in the right form? Is there a specific form for this contract? For instance, power of attorney. So I've seen many people, attempt to pass on interest in land, like sell land through a power of attorney. And there are now like two conflicting authorities that we have. I think both of them of the Supreme Court. One saying, well, you can do it. The other one saying you cannot transfer interest in land. You cannot sell land, through a power of attorney. So you then need to be careful to ensure that, the form in which your contract is capable of transferring the intended interest. And maybe I'll talk a bit about MOUs here.
Okay.
Now, MOUs generally are seen as maybe like a letter of intent, right? A letter of intent. Both of you intend to go into further discussions. Both of you intend to have further discussions and perhaps enter into further terms at a time in the future. If your MOU is drafted that way, then it is not a binding document. It is not a binding agreement. It's not a binding contract. Why is that? Because essentially it is an agreement to agree. It's an agreement for you to go into further discussions. And the law will not enforce an agreement to agree. But if your MOU, for instance, if it sets out very detailed terms and conditions and obligations, then it should be clear that you intend to be binding on you. But because of these different views on whether an MOU is binding or not, first of all, in determining whether it is binding, our courts will look at the terms of the MOU, to determine whether, okay, these parties intended this to be binding. They have very clear terms. They have very clear obligations of each parties. In that case, they would say this is a binding MOU. Or they'll say, well, no, these parties actually said they are discussing and that they'll be entering into further agreements. This is not a binding MOU.
Okay.
I usually would advise parties who want a binding document to state clearly in their MOU that this MOU is intended to be binding. Of course, like I said, if you say this MOU is intended to be binding and the obligations there basically connote of obligations that you are just agreeing to agree in the future or agreeing to have further discussions. That's typically not the type of documents that will be considered binding. So I'll move on to our fourth point, and I'm hoping I can cover all 12 points quickly so that other people can share their experiences, and perhaps we can take a few questions. So the first question is, be very clear about your expectations from each other. The contractual parties need to, as much as possible, be clear about what you expect from the other party. It's almost like taking a mental walk of the contract in your head up to performance and saying this is what will happen. This is what this person is meant to do. This is how this person is meant to do it. And then to reduce it in writing, as far as possible. And why do I say it should be as detailed? I'll give an example. Your contract provides for payments. It says, Murphy, you're going to provide architectural services to me for #1 million, right? But your contract doesn't tell when I'm supposed to make that payment. It doesn't provide for the time of payment. What then happens is that the court will assume, that we intended that payment be made within a reasonable time. The question then is, what is a reasonable time? A reasonable time would then depend on the circumstances of each case, and so it leads you to a lot of speculation if you don't provide specifically, for as much as possible what your expectations are. And even things like delivery. So I'm supposed to deliver something to you, but you don't provide for the time of delivery. The court would also imply that what you intended was a reasonable time. And the same question will arise, what is a reasonable time? And we then have to start showing that, based on the circumstances of this case, the reasonable time is 1 week, it's 5 days, it's 3 days. I mean, to lay those type of things to rest, you probably want to provide in your contract, this is the amount payable, and the amount is payable within XYZ days of, maybe delivering my invoice, or within XYZ days of me performing this, but you want to be as clear as possible about your obligations, the way you want it performed, the time you want it performed, and just have those details so that the default provisions of the law, will not then apply. And so I move on to our point number 5. Our point number 5 is, what happens?
Number 5 or number 4? What
happens when, due to no fault of, I think I'm now on number 5, and I can go through the points again very quickly. So my first point was that you should be careful with contract templates and standard contracts.
Okay.
The second point was that you should do your due
Due diligence. Okay.
diligence. The third point
Know the contract
is
you're getting into.
that you should ask yourself whether your contract is meant to be in any specific thing. The fourth point is that you should be very clear about your expectations from each other. That's point number 4. What your expectations for this to be done. How do you want it to be done? Point number 5 is that it's good that your contract provides for what will happen if, for instance, an event occurs that is not due to your fault or due to the other party's fault, but it then affects the performance of the obligations under the contract. What happens in that kind of event? And you know, and this type of clauses are called force majeure clauses. Force majeure clauses, and the clauses became very handy with the COVID-19. You can imagine contracts that had force majeure clauses. You know, the contracting parties will be able to say, "Well, I have a force majeure clause, and something has happened that has prevented the performance of my obligation," and they will then look to that force majeure clause to determine how parties intend to deal, you know, given the event that has occurred. So a typical force majeure clause will say something like, a party shall not be liable for any failure or delay in the performance of his obligations under this contract, where the delay arises from forces beyond his control. For instance, strikes, accidents, acts of war, you know, terrorism, or acts of God. So what people have argued, for instance, is that this pandemic qualifies as an act of God, and therefore, you know, yes, and therefore falls within the force majeure clause. So what the force majeure clause does is that it excuses a party from its failure or delay in performance. You know, and it would also provide what happens as a result of a force majeure clause. So a typical force majeure clause will say something like, well, if an act of God occurs, or if there's a riot or a strike and it delays performance of the obligation, the time for you to perform that obligation will be extended by the duration of the force majeure event. That's what a typical force majeure clause will provide. It may also then provide that if the force majeure event extends beyond a particular time, say extends beyond 6 months or 3 months, you know, whatever the parties provide, it will say that the party can then terminate the contract. So parties provide specifically, you know, for what happens in the event that something occurs that was not the fault of either party and affects the performance of the contract. Of course, it's not enough for you to show that there was an earthquake or that there was COVID-19. You must actually show that that occurrence impacted the performance or affected the performance of the obligation. So if it was an obligation where you were in default already before the COVID-19 setting, if you're already in default, it will be difficult for you to then argue that the reason for your delay in performance or your lack of performance is the pandemic, you know. So that's really what the force majeure clause does. And people have found that people have found it very useful in the context of this pandemic. The question then is, and as I said, a force majeure clause may provide, you know, that it just delays the performance of the obligation. It may not necessarily provide that the contract is terminated. The question then is, what happens, or what's happening to contracts that did not have or that do not have a force majeure clause? And how have they been able to deal in the course of this pandemic? I mean, for parties that are reasonable, you know, they've probably been able to come together and discuss and find a middle ground. Yeah. I mean, but for others, others may just try to rely on what we call the legal principle of frustration. Okay. So if you don't have a force majeure clause, and a force majeure clause, you can only rely on force majeure if you provide for it in your contract. If you don't provide for force majeure in your contract, you cannot rely on it. You're probably left with relying on something like the legal principle of frustration. The downside of the legal principle of frustration is that it has a very high threshold, right? So what you must show is really high. You must show that it is not just something that is temporary, that occurred. You must show that where it's not that obligation is more difficult to perform it. So the threshold for establishing frustration is much higher. And then the effect of frustration, if you're able to prove frustration, is that you terminate the contract. So if it is not so there's no flexibility really with the legal principle of frustration. So if it is not your intention to walk away from the contract, your intention to terminate the contract, you should consider providing in your contract for what happens if an event occurs that the parties did not, that was due to no fault of the parties. What happens to the contract in that event? Usually called force majeure clauses. That's point number 5. Now I move on to point number 6. And point number 6 is, you may need to ask yourself that this counterparty I'm dealing with, this other person I'm contracting with, is the person entitled to any statutory rights or any statutory protections that may stand in the way of me enforcing my contract against this party? And I'll give examples. If you enter into a lease agreement and you don't provide for the length of your notice to quit, the statutory period for the notice to quit would apply. For instance, this is a yearly tenant, a yearly tenancy, the 6 months notice, a monthly tenancy, 1 month notice. If you want a shorter period of notice to apply, then you should provide for it in your contract. And if you provide for a shorter period, then that's what will apply to the contract. I think another thing to consider are international bodies. So if you are dealing with certain international bodies, they may actually have some immunities that protect them from being sued or protect you from enforcing a judgment against them. And that also happens with countries. If you're trying to sue a country in another country, it's called the doctrine of sovereign immunity. I don't think I should go into that in detail. But suffice it to say that, it's possible that the counterparty you're dealing with has certain statutory protections, and the point of negotiating the contract may be a good point to ask the person to waive those protections. So that when you want to enforce, those protections don't stand in the way of you enforcing your contract against that party. Now we're on point number 7. And point number 7 is, you should also ask yourself, is there an agreed exit? Is there an exit from this contract? Is there an agreed way out of this contract? And what is that exit provision? And I'll give an example. Let's say a particular party to the contract, your counterparty, is not performing the contract or is in breach of a contractual provision, or is not performing according to what you've specified, what are your remedies? Okay. What can you do? It's important to know that it's not every breach of contract that entitles you to terminate the contract. It's not every breach of contract that entitles the party to say, you know what, oh, you breached this contract, I'm walking away. It's not every breach, it's not every type of breach that entitles you to just walk away from the contract. So if you consider the performance of a particular term so fundamental that you want to be able to walk away from the contract if the party does not perform that term, then it will be good to provide for it. And to say that failure to comply with this term, means that the other party can terminate the contract. Otherwise, if you don't provide clearly for that, clearly for the instances where you can terminate for breach, then legal principles will come to play. And those legal principles, in determining whether you can terminate, they'll consider what kind of term was breached. And so in law, they will categorize those terms into 3, what they call conditions, warranties, and intermediate terms. And if the court determines that the breach is in respect of a warranty, then the court will say you cannot just, you may not be able to walk away from the contract. You may not be entitled to terminate. You may be entitled to damages, but not to termination. But the court finds that, oh, it was breach of a condition, because conditions are considered very fundamental terms of a contract. Then the court will say, well, then you have a right to terminate. So you find that if you don't specifically provide for it, you find yourself in court where parties are arguing. One party is saying, oh, this term that was breached is a condition. The other one is saying, no, it was not a condition, it's a mere warranty. And you're just, struggling and arguing whether the term breach is a condition or a warranty. And a possible way to avoid that is to state specifically in your contract regarding certain terms that you consider, are deal breakers to you. To say if this term is not fulfilled, then you're entitled to walk away from the contract. So that's one. Another thing with this point, or whether there's an agreed exit from the contract, is to say, okay, now we've agreed to things that entitle us to walk away from the contract. How do we walk away from the contract? Will I just find a letter in my office when I walk in saying that you've terminated the contract and you walked away from it? Do I want to provide that you give me like 30 days notice of my breach and maybe a chance to remedy the breach? And then if I fail, you exit the contract, Those are the type of things you want to provide for, especially if you know that this type of contract you're entering into is such that you want to be given the chance to arrange for alternatives should a party decide to exit. You don't want the party to just, leave you in a limbo all of a sudden. So that takes us, so that is point 7. Is there an agreed way out of the contract? If there are fundamental terms to you and you want to be able to walk away if those terms are not fulfilled, you probably want to provide specifically for that. Secondly, you want to provide for how a party can walk out. Does it just walk out, or does it give you notice and a chance to remedy? And I go to the next point, which is point 8. How do you settle a dispute that arises from the contract? When a dispute arises, how do you settle it?
Okay.
And honestly, we can spend an entire session just discussing how to settle disputes, because there's several alternatives. So it can be by negotiation, it can be by mediation, it can be by arbitration, it can be litigation. Usually, when your contract doesn't provide for a particular method of settlement, the party's default is to go to courts, right? And if you've not provided for a particular method of settlement, it's very difficult after a dispute has arisen for parties to sit down, and reasonably agree to the type of to a type of settlement. That can be a bit difficult. Okay. So it's important for you to consider looking at the type of contract, the value of the contract, the complexity of the contract, the subject matter, and other things that would help you to determine what's the best method of dispute resolution under this contract. And what you find in most places now is that what I see very common now is that most contracts have like a layered dispute resolution mechanism, where they provide that, well, if a dispute arises, parties must first, talk and attempt at settling the dispute. And then if they fail, maybe the party can go to arbitration if that's their preferred method under the contract, or go to litigation if that's the preferred method under the contract. However, when you provide under the contract that parties should first attempt to settle their dispute amicably, it's important that you don't leave it open-ended. So you should say, for instance, they should first attempt to settle their dispute, maybe within 30 days of notice of the dispute.
Okay.
So that a party who just intends to stall doesn't think he has all the time in the world, to negotiate the dispute. So you actually want to put a time frame for parties to sit together and try to resolve. And if they are not able to resolve within that time frame, then either party can go to court. And the next thing, which takes us to point 9, is, pay attention to the governing law of the contract. I'm sure many of us see this, where we say, oh, the contract is governed by the laws of the Federal Republic of Nigeria. The contract is governed by the laws of the laws of New York. The contract is governed by this or governed by that. It's important for you to pay attention to the governing law of your contract, especially where this is a cross-border transaction, when it's a cross-border transaction. Okay. And why do I say it's important? One is that, you provide in your contract for the terms that governs the parties, right? But when there's a dispute to the interpretation of those terms, it is the governing law of the contract that will determine how you interpret those clauses and the effect of those clauses. And depending on the governing law, they can have very different effects depending on the governing law. So you should pay attention to the governing law of your contract. Now, when you don't provide for the governing law of a contract, especially when it is a cross-border transaction, I'm not talking about transactions between, say, two Nigerians performed in Nigeria and all that. Those ones are clearly, typically be governed by Nigerian law. For cross-border transactions between a party in Nigeria and a party outside Nigeria, when you don't provide for the governing law, then you leave it to the court to determine what the governing law is. And I mean, the court determination at the end of the day may not be favorable to you. It may be very different from what you would have negotiated if you had included it big term in your contract. Because the court will, for instance, look at it and say, okay, where are both parties located? Where will the contract be performed? In trying to determine a lot of complex issues about conflict of laws and all whatnot, in determining what the governing law of the contract will be. So to save yourself that and to ensure that there's clarity, it's advisable for you to agree what the governing law of the contract is. The second reason why the governing law of the contract is important is that, as a lawyer, and I'm sure the lawyers on the platform will agree with me, many times friends and family will come and they'll just send you one contract and say, Joke, please review this for me. And because they know you're a lawyer, then you just flip through and look at the governing law and you say South African law. And you say, Abba, I'm not qualified to practice in South Africa. You should be talking to a South African lawyer, who would understand the impact and the effect and the interpretation of these clauses under South African law. So that's it also affects the kind of regarding the contract, the governing law of the contract. Yeah. So point number 10. Ask yourself or look out. Are there documents that are incorporated by reference into your contract? In other words, your contract refers to a particular document, right? And you haven't seen that document. You should ask to see it. Because chances are you don't know, that document may actually create obligations for you that you're not aware of. And it's important for you to ask to see documents that are incorporated by reference, so that you'll be aware, fully aware of the obligations that you're exposed to, and you know how you want to negotiate the contract. So you don't just see a contract and the contract is talking about this policy, that other contract, that other this, and you haven't seen them, and you just sign up on the contract. You may just have signed up yourself to certain obligations that you're not aware of and that you probably would not have been prepared, to undertake. So if there are documents incorporated by reference, please take the patience to ask to see them and to examine those documents. I would say use your indemnity clause wisely. So what's an indemnity clause? An indemnity clause is simply a clause that says, for instance, that you undertake, for instance, if it's an indemnity from me to you, Murphy, I would undertake to compensate you for any loss that may result to you based on my conduct or based on the representation that I've made to you, okay? And I'll give you an example of one case where I know that an indemnity clause was deployed, in a way that I think was quite creative. So it was a transaction, it was a long lease transaction for a number of years. And in the course of negotiating the lease, it was observed that the party, the landlord on the lease, was different from the party named in the title documents. So the question was, okay, why is it that it is another person, who is entering this lease as landlord or as the sole, and the person is different from the company named on the title document? Can you give us, for instance, a letter of authority, from this person named on the title document, authorizing you to enter into this contract on his behalf or its behalf as landlord? And they weren't able to. And the explanation was that, well, the name on the title document is an error.
Wow.
And that the error was, it was the error of the authority when they were issuing the title document. Because this was a long lease involving, a substantial amount of money, we had to make a decision. The party had to make a decision also based on the party's risk appetite and say, well, do I want to walk away? Is this such a red flag that I want to walk away from this deal? Or are there ways I can cater for this situation by providing, by making provision in the contract, to cover for the situation or to protect you under the contract. So what I know was done in that circumstance was there was a clear provision in the contract that party, has an obligation to correct that error. That's one. And secondly, there was an indemnity under the contract that should any loss result to the tenant on account of that, defect, that this party you were entering into the contract with will, give you full indemnity.
Yeah.
So indemnities are usually quite useful under a contract when you are relied on certain representations of the counterparty, and you probably don't want to walk away from the contract and all that. But there are things that you can deploy quite usefully in a contract. And our last point, and I think I've made good time. So point number, another time you use indemnity that I mentioned is when, for instance, you have a software developer. You enter into an agreement with a software developer to use the software, and you want him to indemnify you if it turns out that the software does not belong to him and you're in breach of intellectual property or something. So you want to include like an indemnity clause. But it's important to know that you can deploy indemnity clauses creatively. And now the last point.
Okay.
Is about restrictive covenants. Restrictive covenants. So restrictive covenants, like a restraint of trade, restrictive covenants, or restrictive terms in the contract. So you find that business people always want to protect their terrain, right? So businessman may tell you, oh, I'm the only person you can deal with. You can't deal with any other person. It's like there's exclusivity. Or you may even find it in the context of employer-employee agreements, where an employer feels that, look, I've invested in this employee, I sent him for trainings here and there. I don't want a situation where he will just hop up and leave me and go and work with my competitor. And so they include a clause that prevents that employee from, from working maybe within a particular geographical area for a number of years. Now, when you're drafting restrictive clauses, it's important to pay attention to any competition law that is applicable. In Nigeria, recently we now have the Federal Competition and Consumer Protection Act. And it has several provisions on restrictive covenants. So you want to be careful that your restrictive covenants that restrains the other party from doing certain things, or that says it must sell something at a particular price, or it must do this, it cannot deal with XYZ party. You want to ensure that it does not violate the provisions of the Competition Act, because if it does, it's not enforceable. And that's almost the same for the restraint of trade with your employees. It is an unduly restrictive clause that says that, oh, the employee cannot work anywhere for 5 years. The courts are not likely to enforce it, because it will be seen as a contract that basically wants to take away his means of livelihood. So for that restraint of trade clause to be enforceable, it must be reasonable. Reasonable in terms of geographical application, reasonable in terms of the number of years. So ensure that your restrictive clauses, your restrictive covenants are not unreasonable, and that they do not contravene existing provisions of any competition law. So that's point 12. And I mean, this is by no means exhaustive. There are several other issues of confidentiality, of legality, and all that. So I think I've covered the 12 points. Now just run through them one after the other quickly, just all 12 of them.
Okay.
So the first point I mentioned, I said, point 1, be careful with contract templates and with standard contracts. And then I talked about ensuring that you know who you're dealing with, using the registered name of the company. I talked about you asking, who prepared the standard document? Was it prepared for the person who was on your own side of the contract? Yeah. Point number 2, I talked about the need to do due diligence so that you know what you're going into, you know the party you're dealing with. Yeah. Point number 3, I talked about asking whether your contract must be in a specific form. Point number 4, setting out your expectations from each other very clearly, so that default provisions don't apply. Yeah. And point number 5 is to ensure that you provide for what happens, if something happens that is not the fault of either party, it will affect the performance of the contract.
Yes,
Point
madam.
number 6 is to ask, are there any statutory rights or protections that you want to negotiate so that they don't stand in the way of you enforcing the contract? Point number 7, is there an agreed way out of the contract? Because it's not every breach of contract ordinarily that results in your right to walk away. And you also want to ensure that you provide for how you walk away from the contract.
Okay.
Point number 8, how do you settle dispute? What method of dispute resolution are you using? And also, the tiered dispute resolution system. Point number 9 is to pay attention to the governing law because it determines how your contract will be interpreted and who you should also engage when you need advice on the contract. Point number 10, are there documents incorporated by reference? If there are, you probably want to ask for them and see them so that you don't sign up on obligations that you're not aware of. Point number 11, you can use indemnities creatively. And point number 12, last but not least, restrictive covenants. Be careful about them, ensure that they are reasonable. Thank you very much.
Okay, thank you so much, Joke. I have just gone to law school this evening. So with all you have said now, I can even attempt to defend a client. That's on a lighter note. Okay, I have questions pouring in, but I want to first of all bring up a colleague, Joke's colleague, to come on board so that the question and answer could be robust. I have a question, so I'll go first. But let me bring him on board. I think I'll ask him to unmute. Where is he? Okay. Can you put on your video? I know you are unmuted. Okay. Okay, great to have you. Good evening.
Hello, good evening.
Okay, your sound is good. Okay, lovely. Okay, so I'll go with my own question first. Joke, you talked about confidentiality clause. Now, the kind of job I do, I'm an architect, I design and build. There are situations where some clients will not want you to disclose to anybody that they are building. Sometimes it could be as bad as a husband will not want you to disclose to the wife that he's building. Now, how can you tread on confidence? How can you tread carefully on confidentiality clauses without being on the wrong side of the law or on the wrong side of the client? How do you draw the balance? Essentially, that's my question. Didam, you can also throw light on it.
I mean, I'm trying to. Dina, do you want to? Maybe I shall allow them.
No, go ahead. Go ahead. No, I think you should go ahead.
So typically, the way confidentiality clauses are, you hardly have a business, it will have certain exceptions. And some of those exceptions are, for instance, if the confidential issue gets into public domain, by means other than through you, then you're free, okay? You have to disclose and several other exclusions of confidentiality. So provided that, you are excused, if by another way the husband comes to know about it, as long as it's not through confidentiality, but I would need to know, for instance, what your real issues are in this kind of situation.
Okay, the real issue.
I mean, but what
now the real issue is this: there may be some circumstances beyond my control. For example, if information goes out that the person has a property or is building and all that, it may not be me. It could be social media. It could be the press. It could be the government. It could be somebody. It could be a whistleblower. It could be somebody. So, but the person will feel that because I am, I am privy to that information, it must likely come from me.
I mean, well, like I said, confidentiality clauses usually have those exceptions. And one of those exceptions is if the information gets into public domain other than through you. I mean, for the person to show that you've breached the confidentiality clause, she must show not only that the information is in public domain, but she must show that it got into public domain through you. If she can't connect it to you, then you're free. It's not enough to show that somebody knows about it. You must show that the person knew about it through me, for me to be in violation of my confidentiality.
Okay, if I may add, so you can hear me, right?
Yeah, I can hear you loud and clear.
Yes, it's because you gave the example of yourself as an architect. I would suppose that sometimes you are also expected to obtain building approvals.
Okay.
If that is the case, I can see where your disclosures will have been made.
Okay.
To where information will have gotten into the public domain.
Okay.
And the title documents and submit them. Anybody in that building approval office could get wind of who owns the property, and that's how information can get leaked out easily. That's for your line of work. That's what I suspect.
Okay.
Maybe one way for information to get out, and that one you don't have any control over. Of course, you can't get building approvals without disclosing the owner of the property.
Okay, good. I'll take more questions, but I'll leave my own other questions for now. There's a question here. Let me read it out. It says, how does one handle the issue of right to intellectual property, especially as it concerns ownership? The partner with the contact to the client, or the partner with that will provide the service, or in the case of clients and software developer, how should this be argued? Is that very clear, Didam?
Honestly, that's not very clear to me. I'm not sure I understand the question.
Okay, maybe the person will have to rephrase it. Let's go on so that we can take more questions. This next one says, how do you handle cases of insecurity and trust between partners going into an agreement? Is there any legal way of assuring trust before going into an agreement?
If I may attempt an answer here, I'm not sure. Trust is a thing of individual.
It's subjective.
It varies from individual to individual.
Okay.
The best you can do is, yeah, exactly. The best you can do is reduce it into writing in print.
Okay.
Whether a party would keep to the terms of a contract is another thing. There are people who, no matter how watertight your agreement is, if they intend to breach it, they will still do it. So you can, I'm not sure you should work on trust alone. Just put in all the clauses, like Joke said, that will protect your interest, so that in case there's a breach, you can always have recourse to some remedy. I don't know whether I've answered that question well enough, but
yeah, I think
I was also going to add that. Yeah, I was also just add that if there are specific trust issues that you are concerned about, I think one of the challenges with contracting parties sometimes is that they speak in parables. So the clearer you are about what your real issues are, about what your concerns are, the more possible it is for your lawyer or the person drafting to provide adequately for those issues under the contract. So my question, for instance, would be, what are the, apart from general trust issues, are there specific trust issues that you are, that you are concerned about? And if there are specific trust issues you are concerned about, then let your lawyer know those trust issues so that they can provide adequately for how to address them, what kind of obligations to secure them, under the contract.
Okay. Another question here, but I'm not sure it's clear. He said, I have questions around affordability and jurisdiction. I don't know what is referring to there. I think you may need to clarify. Someone says, for force majeure, what sort of evidence is acceptable? COVID-19 as an example, would an article talking about shipping delays at the port be viable? So I guess this person might be a supplier, bringing in things from out of the country. So he's asking that, can he declare force majeure? And can he have an article saying that there are delays at the port and all that?
I mean, I think that with force majeure, first is that, I mean, with COVID-19, for instance, it's public knowledge. So I doubt that you walk into any court and the court will say, oh, you need some, really high standard evidence to prove that there was a pandemic. But if it's other types of force majeure, like what you said, delay at the port or something,
yeah.
An article could help you to show that, but you'd also probably have to show that delay was at the time that your goods were meant to come in. So you need to tie it to the period that your goods were meant to come in, and not just a delay occurring at some random time. So so yes, that should be helpful. If your counterparty has evidence to show that is wrong, or that is not true, then the onus goes back on you, or back to you, to try to establish it by other means. But as a first step, that should be good evidence.
Okay.
An article may be good evidence. Some kind of documentation from the port authority may be good evidence as well. You may have to call someone or someone who works in the port authorities to come to give evidence. I mean, there are several ways depending on the facts of the case.
Okay, thank you very much. This next question says, what can you say about an agreement with a condition that the agreement cannot be contested in any court of law in Nigeria?
Okay, so there are two things I'd like to understand about that question. Is it just saying you cannot contest it in a court in Nigeria, or you can't contest it in court at all? And the reason why I ask that question is, parties sometimes agree to a foreign jurisdiction clause. And what do I mean by a foreign jurisdiction clause? It's a clause that says, if any dispute arises between us, we are going to take it to the courts of XYZ country. Okay. So we may choose that the disputes that arise between us will not be settled in Nigerian courts, or be settled in the courts of another country. Now, generally, courts will enforce that kind of provision where the parties agree to settle their disputes in the courts of another country. Of course, we can talk at length about that as to the cost that may involve and all whatnot. So as a general principle, courts will term in a contract. Of course, there are exceptions to when the courts will enforce that kind of term. But if it's a general provision saying that you cannot bring a claim for any violation of the contract at all, then it is likely that it will not be enforceable.
Then it's a red flag.
But if it is just one specifying that specific courts are the ones that will have jurisdiction, then the courts are likely to enforce it and say, yes, you should go to only the courts that you've agreed will have jurisdiction.
Okay. This next question, I think, is a bit long. If a client has assets in multiple countries, including Nigeria, and wants to create a will instructing how assets are allocated even in the event of death, how is this best addressed considering the different legal jurisdictions? Is the question clear?
Okay, Dindam, do you want to?
Yeah, the question is clear. First of all, well, there's when you mention different jurisdictions, I don't think there is a way to go around it. You have the will, quite okay, but every jurisdiction has requirements for is it enforcing the will? In fact, in Nigeria alone, all the states, every state has its own different procedure. So once you have a will that is registered in one jurisdiction, even within Nigeria, before you can enforce that will against a property in a different state, let's say you registered it in Lagos. If you want to enforce the will against a property in Plateau State, you still have to take that for resealing within Plateau State for you to have control over that particular property. So the same thing happens with multiple countries. If you have a will in Nigeria, how you are able to use that will in, say, the UK is subject to the laws governing succession in the UK.
Okay.
So you have to still follow procedure there. The only way you can deal with it is have a will covering all the properties. But once it gets to actual execution of the will, you have to be subject to all the laws in the jurisdictions.
Okay. Joke, do you want to add anything to that?
No, no.
Okay. Somebody here says it's important for parties to be able to have adult conversations. Talk about your concerns. I'm not sure I'm clear about that.
I think that's a comment. I don't think it's a question.
Okay. Okay.
Probably encouraging people to ask questions.
Okay. Okay. Please, if you have questions, please type it in the comments section. I will take it. This one says, great presentation. What's your advice on how to improve the chances of speedy judgment and enforceability of contracts when dealing with a Nigerian counterparty wholly based in Nigeria, contracts under the law of England and Wales? Is that clear?
Well, I won't say it's very clear, but maybe the way I understand it is that
enforceability.
I mean, so the way I understand that is that the law governing the contract is the law of England and Wales, right?
Yes.
And what really is the role of the law governing the contract? You know, I think I'd explained in the course of the presentation that that's the law that will determine how the contract is interpreted, how your obligations are interpreted and effect. So if that contract just provides that it is governed by the law of England and Wales, but doesn't, for instance, say that we must subject it to the courts over there, then it's possible for me to file my action in Nigeria, but it will be governed by the law of England and Wales. What will just happen in Nigeria is that when I want to give evidence as to the law of England and Wales, I may need to call expert evidence. You understand what I'm saying? Okay, also subject to the court in England. Okay, so if you have a judgment from a court in England and you want to enforce it in Nigeria, there are provisions in Nigerian law for the enforcement of foreign judgments, you know, and part of the provisions, I mean, there are several things to consider. One is reciprocity. So does that country also recognize the judgment of Nigerian courts and all whatnot? And there's a procedure for it. So that procedure has to be followed for enforcement of judgment. And, you know, maybe I can just chip it in here. One of the reasons why arbitration is very attractive as a dispute resolution, you know, alternative, as a method of dispute resolution, is the ability to enforce arbitral awards in over 160 countries. If it is an international arbitration award, you know, that was made, you know, in a country that is a party to the New York Convention. So enforceability is usually much easier, if I may say, with international arbitration awards. And that's why there's an attraction, you know, there's a major attraction for arbitration.
Okay. I want to ask this question. Yes, I think you did justice. I want to ask this question. Two things. The first question, are email evidences, are they tenable in the court of law? Number one. Number two is that we now notice that on social media, when people, Mr. A want to accuse Mr. B, they will do a screenshot of their chats and say, you said you promised to marry me. Now you say you're not going to marry me and all that. Can you tender screenshots in the court of law? Somebody can steal my phone and chat with you and claim it's me. The phone may not be in my possession. Does the court recognizes, number one, email evidence? Because I can borrow you money and you say you return it next week, and I'll tell you, do an email for me, and you do an email that, okay, borrow me 100,000 till next week, and you don't honor it. Is the email an evidence, and are the screenshots also tenable in the court of law? Dinda.
All right, thank you. I'll leave that for Dinda.
Dinda, please.
Okay, sorry. The answer is actually, yeah, I have. The answer is actually very, very straightforward and brief. Yes, it's admissible. The Evidence Act that we currently use in Nigeria allows for admissibility of electronic evidence. And this is evidence generated from any electronic source, whether email, phone chats, screenshots, all of them are admissible, provided you follow the procedure for tendering them in court under the Evidence Act, which we wouldn't have the time to go over that at the moment, but it's admissible.
Okay. Again, am I permitted by law? Am I permitted by law? For example, this is a case between husband and wife. Is the wife permitted by law to tap the phone of the husband? That's put a wire on the husband's phone, maybe suspecting the husband here and there, and he wants to get fact. By law, is she permitted? Or does she need
There's no law that.
Does she need to get a lawyer to?
There's no law that everybody is entitled to privacy, and the right to privacy is an individual one. So there is no law that allows you to violate another person's own. That's just a simple answer.
Okay. There's a long question here. I think we'll divide it. The first one says, how affordable are legal services in Nigeria? Well, I think that's also a subjective question.
I can answer that one. It's very affordable.
Okay, good.
It is.
The second one, how would you advise a service provider based in Nigeria and who serves clients and secures partnerships with entities dispersed in various countries to go about navigating the conversation around jurisdiction? For example, clients and partners in UAE, UK, USA, etc. I think this person is an IT specialist, and so probably he has contracts with Google, with Cisco, with a few of these service providers. So I think that's why he's asking this question. He said one such partner based in the States once turned a previously smooth conversation into a take it or leave it scenario. Should I insist on dual jurisdiction?
Okay, I think insisting on dual jurisdiction can lead to a lot of confusion. So it's really not in your interest to insist on dual jurisdiction. And what I've found, for companies that deal in different jurisdictions, is that they tend to have a standard form dispute resolution form for practically all their contracts, instead of having to renegotiate that particular term. And what I've also found parties to do, especially when they're in different jurisdictions, and they can't really agree on the jurisdiction clause, is for the true of my country. Now, I don't want yours. I'm comfortable with. Neutral jurisdiction, you also want to be careful. I am not choosing it just because it's not the law of your country or the law of your counterparty as well, but that law caters adequately to the subject matter of your contract. So that's what typically happens. But providing for multiple jurisdiction clause is going to create more confusion than a solution.
Your network is a bit poor, Joke.
Yeah.
Okay, Dinda, you have something to add? Okay, she's still talking.
Okay, she's back.
I don't know whether you heard me or what you heard. I think
Network is a challenge. Yeah, it's a challenge, but what she was trying to say is that having multiple jurisdictions can just create confusion.
Hello, Joke, can you hear me? Okay.
Okay, if she can, yeah, maybe. I think your bandwidth is low down right now. What I was saying is, I think what she tried to.
I can hear you. Can you hear me now?
Yeah.
Yes, we can hear you now.
Okay, we can hear you now. We can hear you now.
Okay, so I think the person is clarifying.
No, then.
Is saying the fear with one-sided jurisdiction.
Hello, can you hear me now? I'm actually...
We are losing you, Joke. Okay, you are using Fall on Short's phone. Okay, go ahead. It's still poor.
I think it's still poor, yeah.
So what I was saying is that, you know.
Okay, she went off.
Yeah, she went off. So, sorry, like I was saying, she said having multiple jurisdiction clauses may put up a lot of confusion sometimes. Okay. But I see that the concern the person who has asked the question has. For example, he said in one of such instances, a previously smooth conversation suddenly turned into a take it or leave it scenario. Now, it depends on the strength of the contracting parties, the positions in which they are coming from. A party, certainly it's not all the time that you have equal parties when you want to enter into agreements. There may be a dominant party because of the position it occupies or what it's actually providing. I've seen in practice, for example, I don't want to mention any company's name, but there is a very big IT company that in most of the contracts have had the opportunity. They have always come with standard templates. You either sign what we have as our template or you leave it, no editing, nothing done to it. So it's for you who is contracting to make the decision as to whether you want to agree to the standard template or the standard term contract and sign. Okay. If you have a strong enough bargaining power, you can push back, maybe get a few concessions here and there. But if it's not going to work, then it's either the contract is it's not going to go through. You just walk away. But I know that there are contracting parties that there's not much you can do about it. They insist because they have a lot of people they can sign the contracts with anyway. Okay. So they usually take that position sometimes. But one way to also make a concession for multiple jurisdiction clauses is to be careful. You cannot have. You can try to insist on certain aspects of the contract. You know, the contract may be multifaceted. You could say for this aspect of the contract, let's say this jurisdiction would be in charge of it. Say there is something that is supposed to be done in Nigeria. It can be agreed that for that aspect of the contract, any dispute that arises from it should be determined in Nigeria. And for the other aspect, then we can determine it in your own jurisdiction. But ultimately, it's for parties to be willing and to agree to these clauses. Contract is said to be a contract only when there is an agreement of the minds. If both parties don't agree, then it won't work. Okay. I don't know whether if the question is not answered clear enough, the person can still send in
I think
clarification or something. We can always.
Yeah, Joke says she's back. Okay, let me.
Can you hear me now?
Yes, we can hear you.
Okay, yes, we can. You're back now.
Fair to you.
Yeah.
Yeah, I think Dinga basically answered the question already. What I was just going to add, or what I was trying to say is that agreeing to a multiple jurisdiction clause is probably not the best bet because it's likely to cause more confusion and all whatnot than a solution. And I was saying that sometimes what I found that companies do, or contracting parties do, is to then agree a neutral jurisdiction. So for instance, I want the jurisdiction to be Nigeria, and the other party wants it to be their own country. And so we can meet midway and say, well, let's choose a neutral jurisdiction. And of course, you should also be careful in choosing that neutral jurisdiction. So you choose it not only because it is neutral, but you want to ensure that it can cater adequately to the subject matter of your contract. You know, but I mean, I think Inam already mentioned the bargaining power, and that sometimes in reality, I mean, we just need to be practical.
Okay, Joke.
Sorry. Yeah. I think she has finished.
Okay. Okay, so we are getting ready to round up. If anyone has any question or contribution on any of the points, on any of the 12 points Joke has shared, please, you can, if you don't want to type, you can quickly unmute your mic and quickly ask before we begin to draw to a close. Well, if you want to type in the comment section, it's fine. You can type. Joke, can you hear me now?
Loud and clear.
Okay.
Can you hear me too?
Yes, I can hear you. So in the absence of questions, I want Dindam first, then you next, to give us like some closing shots. You know, I know we have said a lot, and we are also recording. So this video is available on YouTube. After this session, in the next 2-3 hours, it will be uploaded, and people can go and check it out and listen to it again. But I want you to give us some parting shots. Dindam, you first, then Joke, you next, then we'll call it a day. Dindam. Hello? Dindam, can you hear me? Just give us some closing remarks.
Okay, yeah, I couldn't hear you for a while. I don't know what happened.
Yeah, so give us some closing. We're about to close.
So I don't know what.
We're about to close.
Oh, okay.
I want you to give us some closing.
I think it was
Sorry?
Yeah, I said it was an insightful session. I like the questions that came from those who asked.
Okay.
I'm glad to have been of help.
Okay.
I'm glad to have been of help. Even though I saw a particular chat, I don't know whether that had been addressed when I couldn't hear you. I would have loved to know what happened at the end. Somebody said a fight broke out in their compound because of a contract that wasn't.
I think it was talk when I asked the question about chats.
Yeah.
That can chats be acceptable in the courts? The person made that comment that the police used the chat to shut the case. So I guess that was what they settle the case.
Okay, that's so I thank everyone for staying on and listening and asking questions as well.
Okay.
I hope that there will be more opportunity to do this. I'm thankful as well, and I'm grateful for the opportunity you've provided. Thank you.
Okay, thank you. We hope to have you again. Joke, some closing remarks from you.
Okay. Right. I mean, I feel very at home on this platform.
I don't hear you well.
Hello, can you hear me?
Not well.
Hello, Murphy, can you hear me?
Yes, it's now okay.
Yes.
Hello, Moki, can you hear me now? Thank
Yes, I
you.
can
So I
hear you
said
now.
that I feel very as a participant, and it feels partly like I'm back in Baduri.
Okay.
But as a closing remark, what I would like to say is, the value of seeking early legal advice, it far outweighs the cost, the eventual cost of not seeking one, especially when it arises. So I'd like to encourage everyone, seek early legal advice, very early in your contract to avoid avoidable mistakes. And it's been a pleasure being on the platform. Thank you very much. Thank you to everyone.
Okay, thank you, Joke, for honoring our invitation. Thank you, everyone that came on board. I want to appreciate everybody for joining. This video will be available on YouTube. So in the next few hours, just go on YouTube and type my name, Damilola Mufikoya, or type the topic of this session onto your YouTube browser, and you can download the video and listen to it and share it with friends, and go back and listen over and over and over again. Thank you everyone for attending. Thank you everyone for being part of this. So many people here, so too numerous to mention. I appreciate you all, and see you again next time very soon. Thank you all. God bless you. Thank you for joining. Good night.